So we'll just give it a couple of minutes to let people trickle in. All right. Well, welcome everybody to the University of New Mexico Law and Mental Health Didactic Series. This series is hosted by the University of New Mexico Department of Psychiatry and Behavioral Sciences and the New Mexico Behavioral Health Services Division. We're so glad to have you all here joining us today. My name is Julie Brovko. I'm an assistant clinical professor in the Department of Psychiatry and Behavioral Sciences. Next week, we have Dr. Lisa Drago-Pachowski, who is presenting key concepts in the forensic assessment of disability. For our talk today, as always, please ask your questions in the Q&A. Whenever you feel comfortable, just know we're not going to get to them until the end. As always, we try to get to as many of your questions as possible, but please forgive me ahead of time if we can't get to yours. For those of you who want CEs but are on a tight schedule, you do have to stay for the full hour, but you don't have to stay longer than that. So we'll probably be staying on a little bit past the hour to address questions. But once the hour hits, if you need to jump off, you're welcome to. You can still qualify for those CEs. For those of you that are here for CMEs, those are the medical CEs. You want to go to the sign-in link in the chat that's posted right now. For those of you that want the APA CEs, you want to wait for the last 5 minutes of the talk today. We're going to post the link in the chat. We are not going to email it. So we're back to grabbing it from the chat 5 minutes before the talk ends. Remember, complete the survey, take a screenshot, save it, print it, do something with it because we don't email them out to you after the fact. All right. Oh, and for the recording, we will be posting that in about a week. We are not sending the PowerPoint, okay? So please take your notes now, watch the recording later, but no, you're not gonna have access to the PowerPoint after the talk today. So now I'd like to introduce to you our speaker for today, Mr. Clarence Sundram. Mr. Sundram's a nationally recognized expert on conditions in institutions and community programs for persons with mental disabilities. Currently, he serves as the independent monitor for the federal court overseeing the implementation of a settlement agreement class action, which offers approximately 4,000 persons with mental illness residing in adult homes in New York City the opportunity to move to supported housing with support services. He's also served as an expert witness, mediator, special master, and court monitor in landmark civil action lawsuits in several states involving the rights of persons with mental disabilities, including the Willowbrook case in New York, Wyatt in Alabama, Heinlein case in Maine, and the Forest Haven case in Washington, D.C. He served as the president of the board of directors of Disability Rights International and has participated in international efforts to reform mental health services in Argentina, Armenia, Bulgaria, Hungary, Kosovo, Mexico, Paraguay, Peru, Romania, Serbia, Turkey, the Russian Federation, and Uruguay. Mr. Sundram has published numerous articles in legal and other professional journals and is a frequent speaker at national conferences. and he's appeared on such programs as Nightline, 48 Hours, and the CBS Evening News, and he has received several awards in recognition of his public service. Mr. Sundram, thank you so much for being willing to present today for our series. I'm honored to welcome you, and I want you to know that we're grateful for your time and expertise today. I'm now going to turn it over to you. Thank you so much.
Thank you very much, Julie. It's a pleasure to be with everybody this morning. It's afternoon here in New York, but I'm glad to be here to share some thoughts with you about a subject that occupies a lot of my time. What I'm going to talk about today are three things. Oh, I should make this disclaimer that I don't have any financial interest. I wish I could tell you that they were giving me a sack full of money to do this talk, but they're not. So I don't have any financial interest in it. And the views that I'm going to express are my own. So I take responsibility for everything that I say, and I won't blame anybody else for it. So what I'm going to talk about today are three things. First, how systems reform lawsuits are different from other cases with which you may be familiar. Second, the special role of professionals in all phases of these types of cases. And third, the typical life cycle of such cases and how their long duration makes them susceptible to changing conditions and the keys to successful implementation. Let me begin with how these cases are different from traditional lawsuits. When I talk about structural reform, I'm discussing the class of lawsuits which are generally focused on changing the way in which government does business, so as to protect and vindicate the rights of people who receive services from government. These could be students receiving special education services in public schools, inmates in jails and prisons, residents of public housing programs, patients in mental hospitals or developmental disabilities facilities, children in foster care, and so on. For the non-lawyers in the audience, it is essential to understand that the types of cases we're talking about are different from those with which you might be familiar, where one party is seeking damages from another for injury or breach of contract, or even equitable actions to enjoin a particular action, such as tearing down a building of historic value. These types of cases seek to direct a future course of behavior that is required to protect the rights of a plaintiff class. And they often prescribe in considerable detail how discretionary choices that are typically available to government are to be made. They also have a significant impact on the allocation of resources between competing claimants, often for many, many years into the future. For example, the litigation over the rights of residents of mental institutions in Alabama commenced in 1970, and the system was not ultimately released from judicial supervision until 2008. During that time, the state of Alabama replaced virtually all of its old and dilapidated institutions with new, modern, and code-compliant facilities. It later invested tens of millions of dollars in developing community services. The potential that these cases have to substantially increase the budget of a governmental agency that is nominally the defendant in the action may lead to a less than spirited defense, as the agency that's the defendant sometimes welcomes the budget increases. In the Willowbrook case in New York, which was brought in 1972 and involved a class of 5,000 people living in a state institution, the settlement occurred in 1975 as the city and state were teetering on the edge of bankruptcy. Some of you may remember this headline announcing the federal government's refusal to assist the city of New York. The governor had gone to President Ford asking for assistance, and the Daily News captured the response very succinctly in this headline. Although there were massive cuts in virtually every area of governmental operations, and the state had made significant investments to develop community services for the Willowbrook class, while simultaneously increasing the staffing levels and the physical environment at the institution. This is just one type of effect that these kinds of cases have upon government and the decisions it can make. These cases are also notable for the effect they have on third parties that are not directly involved in a lawsuit. Among these impacts are the alteration of the normal course of governmental contracting and requirements for competitive bidding, the effects it has on labor unions and the contracts they have that generally prohibit the contracting out for goods and services that have traditionally been provided by organized labor. And it has effects on local governments and their traditional powers, such as zoning. In the Willowbrook case, zoning in particular became a very important issue. The state was required to create hundreds of community residences to house the 5,000 residents of the Willowbrook institution. Most localities had no experience with this type of housing and reacted with fear about what this would mean to property values and the nature of their communities. Initially, some of the houses purchased to establish group homes were burned down before they could be occupied. Soon, zoning boards in different localities passed ordinances forbidding the location of group homes in residential neighborhoods. So the state found itself caught between a federal court order requiring the development of these group homes and local zoning boards forbidding their placement in residential neighborhoods where normal people would want to live. Eventually, the governor proposed and the legislature passed a law overriding the ability of zoning boards to ban group homes from residential neighborhoods. And today, there are hundreds of such homes all across the state, and they've become an accepted part of the local landscape. Now, unlike traditional lawsuits, where the issuance of the judgment is usually the last action taken by a court, in these types of cases, the impact of the court's judgment lasts longer after the judgment has been issued. In Washington, D.C., a case involving the closure of the Forest Haven institution, the case lasted for over 40 years between 1978 and 2017. In Alabama, the Wyatt case that I referenced earlier began in 1970 and did not come to an end until 38 years later. And in New Mexico, the Jackson case was brought in 1987 to correct unconstitutional conditions at the two state institutions for people with developmental disabilities and to remedy violations of the Federal Rehabilitation Act. And it has just ended in 2022, 35 years later. The Willowbrook case, which commenced in 1972 and ended in a consent judgment in 1975, was not formally ended until 1993, and it is still the subject of ongoing monitoring that will continue for the lifetime of the original class members. These are just a few of the examples of these types of cases across the country. The court's involvement is also more complex and intrusive after the judgment than during the liability phase of the litigation. In part, this is because there are much clearer and more rigid rules of procedure for the liability phase than for the exercise of a court's equitable powers during the post-judgment phase. To illustrate this, during a trial, the evidence that is produced must be competent, relevant, probative of some factual issue that is in dispute. In the post-judgment phase, a judge is free to inquire into issues that might affect the ability of the defendant to implement the relief that is ordered. Status conferences with the court are informal, with attendees addressing the court freely and not under oath. Progress reports to the court are not subject to cross-examination. The informality and flexibility permits the court to keep informed without drowning in legal process. So in one case where it was clear that the state would need additional appropriations to implement the remedial measures, the judge invited the chairpersons of the legislative fiscal committees to a meeting in chambers to discuss with them the importance of appropriations to support the implementation of remedial actions. This is something that would never happen during the liability phase of a case. In addition to the greater discretion that judges have in overseeing the implementation of structural reform orders, they also have access to specialized assistants to carry out this role. The inherent powers of a court to enforce its judgment authorize the appointment of judicial adjuncts, such as special masters, court monitors, and similar agents to assist the court in implementing its orders. So while judges may have no particular expertise in the management of a complex governmental system, such as a prison or a mental health system, they can find experts to assist them in this work. And for much of this work, the traditional adversarial rules of litigation are suspended or attenuated. These judicial agents are often permitted by orders of reference to engage in informal conversations with the parties to the lawsuit, to provide consultation and mediation of disagreements between the parties, and to inform the judge regarding progress in implementing court orders. Much of this work of judicial adjuncts is done informally. A monitor or a special master may speak to the parties directly, interview their employees, review documents, convene parties' meetings, engage in informal dispute resolution, make recommendations regarding the course of action to follow, and so on, all without the traditional adversarial process of litigation. Another significant feature of these types of cases is the prominent role of plaintiff's attorneys in the post-judgment phase. Although there are usually named plaintiffs representing a class in these cases, the real driving force behind the litigation is generally a public interest organization and its attorneys, or the United States Department of Justice, which has an institutional commitment to reforms that are being sought through litigation in civil rights cases. In the Jackson case in New Mexico, for example, the New Mexico Protection and Advocacy Agency's lawyers were joined by attorneys from the University of New Mexico Law School, the Center of Public Representation in Massachusetts, the Public Interest Law Center in Philadelphia, and so on. And these institutional plaintiffs and the court tend to be in these cases for the duration, even as there continues to be turnover on the side of the defendants. So let me turn now to the second important feature of these cases, which is the prominent role that professionals play in virtually every step of the process of litigating a systems reform class action lawsuit. And there are professionals of many stripes involved. In the case of mental health and developmental disabilities field, these are usually clinical professionals like psychologists, psychiatrists, social workers, nurses, PTs and OTs, and the administrators of such programs. In cases involving prisons, they're usually professionals who have had experience in these environments. Often people who have had experience as superintendents, commissioners, or other high-level administrators are also involved. And their involvement may take many forms. The first is establishing what the standard of care ought to be. The court must grapple with the question of what is constitutionally adequate care in the types of systems that are under litigation, especially in the early 1970s, when the first cases like Wyatt versus Stickney in Alabama or the Willowbrook case in New York were being brought. There weren't many generally accepted standards about how institutions should operate. The American Association for Mental Retardation had been involved in a multi-year effort of trying to develop standards, mostly as a tool to provide leverage with legislatures to obtain adequate funding for institutions that were widely regarded as being custodial and bad custodials of that. So the federal courts turned to professional organizations for guidance as to what the standards ought to be. Similar things happened with standards of the Joint Commission on Accreditation of Hospital Organizations. And correctional facilities and juvenile detention facilities have their own standard-setting organizations, which rely upon professional opinion for their development. An essential point to keep in mind, though, is that what may be clinically or professionally desirable as a standard is not necessarily the same as what is constitutionally required, which is usually considerably less, often couching them as, quote, minimally adequate, close quote. However, the standards tend to be rather vague, and in the context of litigation, courts need to have evidence pertaining to a specific facility or facilities whose conditions are being challenged. In some of these class action lawsuits, the constitutional standard of care is, quote, deliberate indifference to serious medical needs, close quote, or service in the, quote, least restrictive environment, close quote, or to establish that the services being provided are, quote, a substantial departure from prevailing professional standards, close quote. So the second role of professionals is to provide an expert opinion on what the prevailing professional standards are and compliance with or the substantial departure from such standards. Plaintiffs' attorneys would typically arrange for teams of professionals to tour facilities, collect evidence, express a professional opinion on the adequacy of care in these facilities. These professionals face two challenges. First, what is the prevailing standard of care? And second, its adequacy in protecting the constitutional rights of patients to be safe from harm, to receive adequate care in exchange for the deprivation of liberty, and to be provided this care in a manner that is least restrictive of liberty. And on each of these questions, the defendants would have their own teams of professionals to challenge the opinions of the plaintiff's experts. I won't bore you with the ins and outs of litigation and the need for expert reports, deposition testimony, motion practice, etc. Suffice it to say that if these cases survive a motion for dismissal and go to trial, professionals once again take center stage in their third role as an expert witness to establish the constitutional and statutory violations that prompt the need for systemic reforms. Assuming plaintiffs prevail, the court may rely upon the professional opinion of experts in fashioning remedial actions, a fourth and important role. This may happen in several ways. First, the court may invite both parties to propose remedial actions, or it may delegate the responsibility to a special master to investigate and propose remedial actions. In the Evans case in Washington, D.C., for example, after the federal judge had held a trial and found the defendants in non-compliance with previous court orders, she delegated the responsibility to me as a special master to hold hearings and propose remedial actions to correct the non-compliance. In either case, the remedial actions are likely to be drawn from professional opinions of knowledgeable experts. Next, as I will discuss later in the talk, the implementation process in these systems reform cases typically spans a period of many, many years. It is not uncommon for the court, as part of its remedial order, to appoint a court monitor or a special master as an agent of the court to monitor the implementation of the orders and to provide the court with periodic reports on compliance. Often these court officials are people with an acknowledged professional expertise in the subject matter of the litigation, a fifth role. For example, in a recent case in Mississippi involving its mental health system, the judge appointed the former mental health commissioner of New York to be the special master. Alternatively, if the court appoints an attorney or a former judge to this role, that person in turn relies upon professionals with subject matter expertise as part of a monitoring team. This input usually becomes critical because the process of implementation is rarely smooth and often requires course correction. Expert professionals, especially those with wide experience in the particular field, can often bring experience and judgment to guide such changes. For example, in suggesting training and behavioral intervention to prevent the unnecessary use of force in correctional facilities, or strategies for reducing the use of restraints and seclusion in psychiatric hospitals, or programming to reduce the reliance on psychotropic medications for behavioral control. Finally, at some point, a determination of compliance with the court orders must be made. And although this is a legal judgment, it is usually informed by the opinion of expert professionals. So let me turn now to changing conditions. One of the consequences of the long life of these cases is that the world changes while they're going on. When many of these cases were brought in the early 1970s, there were few standards in existence to govern the expectation of care in institutions. It was left largely to the community of professionals who worked in these institutions to determine what was acceptable. So it is into this void of standards that the federal courts stepped in and essentially faced the task of adopting standards to apply to institutions for persons with intellectual disabilities. Of course, they sought input from experts in the field and relied to some extent upon the developing standards. The wide standards that were embodied in a district court order in Alabama in 1972 were among the first legal codification of standards, a lot of which eventually made its way into federal regulations years later, and some of it into international standards that are embedded in UN declarations and covenants. And these federal standards themselves have undergone significant changes and further developments in the law in the 30 to 40-year lifespan of these cases. For example, in the 1970s, the federal government promulgated standards for state institutions for the mentally retarded, as they were then called, to receive federal Medicaid funding. These standards were later extended to provide funding for small community facilities. In the 1980s, the Home and Community-Based Waiver Program further encouraged the provision of services in the community by creating more flexibility to support community living. In the 1990s, Congress passed the Americans with Disabilities Act, announcing a broad policy of non-discrimination on the basis of disability in many areas of life, including employment, opportunities to purchase goods and services, and to participate in state and local government services. And in 1999, the Supreme Court, in the case of LC versus Olmstead, held that unjustified segregation of persons with disabilities in an institution constitutes discrimination under the Americans with Disabilities Act. And further, that public entities must provide community-based services to persons with disabilities when such services are appropriate, again, relying upon professional judgment of treating professionals. Second, when the affected persons do not oppose community-based treatment. And third, when community-based services can be reasonably accommodated. You can see the impact of these changes in the law on the patterns of service delivery. This slide shows the decline in institutional beds in the developmental disabilities service system from a peak of 194,000 in 1967 to less than 19,000 in 2017. And you can see the concomitant growth in the number of people getting Medicaid-funded supports to live in the community. Similar patterns of decline in institutional care can be seen in the mental health and juvenile justice institutions. So in this changing landscape, you have cases like the Willowbrook case in New York, which ended in court orders issued in the 1970s and have very specific and detailed requirements that the state defendants are required to implement. I've been observing the implementation of these cases for over 40 years from many different vantage points. I've worked as a law clerk in New York appellate courts, dealing in part with judicial decisions about public agency compliance with legal obligations. I've worked as an assistant counsel to the governor of New York, defending class action lawsuits against the state mental health and prison systems. I ran an agency responsible for monitoring the mental health and developmental disability systems in New York and administering a federally funded advocacy program that initiated lawsuits like these. And I've served in a monitoring capacity in class action cases in several states involving large human service systems, mental health services in prisons, the closure of mental institutions and transitioning people to community programs, and in special education services in an urban school district. In looking at how states have approached the task of complying with court orders, it's useful to think about compliance from a couple of different perspectives. First, there is structural compliance, which refers to the conditions that are necessary for compliance to occur. Generally, these are inputs: having adequate staff, staff training, policies and procedures, case management ratios, and the like. The defendants generally emphasize this because these are things over which they have better control. Establishing standards, creating programs, writing policies and regulations. Here again, professionals play a key role in informing what these standards and regulations and policies should be. These structural elements are necessary preconditions for compliance to occur, but they are not usually by themselves sufficient. Actual compliance is the outcomes that were sought by the plaintiffs, such as safety, protection from harm, adequate medical and mental health care, individualized treatment, least restrictive environment, and the like. These are much more complex goals. They're not easy to measure, and they're subject to many influences that the defendants don't directly control or don't completely control. The plaintiffs emphasize outcomes for people because this is why the lawsuits were brought in the first place. So let me walk you through a typical life cycle of a systems reform case. In examining a number of these cases over the years, which have been going on, they have all run through a fairly typical life cycle. Stage one is euphoria at having settled a difficult lawsuit. Everyone is delighted that they were able to find a legal solution to some thorny problem of running a mental health system or a prison system or providing special education services. There's usually a honeymoon period, which may last a year or two, and a degree of goodwill between the parties as the work of implementation gets underway. This euphoria is understandable. The litigation leading to a court order is often long and difficult. As an example, the adult home case in New York, in which I'm currently working, began in 2003 with a complaint by disability advocates, an advocacy agency, that the state was violating the rights of mentally ill residents by segregating them in board and care homes when most would prefer to be living in community housing and would be qualified to do so. The ensuing 6 years was consumed by legal process, motions to dismiss, motions for summary judgment, discovery, depositions, and eventually an 18-day-long trial, at the end of which the judge issued a 210-page decision finding that the state had violated the rights of the residents under the ADA. There were additional legal proceedings about what the remedy should be. Again, both sides relied heavily on professional opinions regarding an appropriate remedy, before the court ruled in 2010 that the residents had the right to move to the community if they so chose. The state appealed the decision. And 2 years later, the appellate court decided that disability advocates, which brought the lawsuit, did not have the standing to bring it and vacated the lower court's decision. So it was back to the drawing board with the prospect of relitigating the case with a plaintiff who did have standing. The United States Department of Justice then entered the case, and it clearly had standing, as did several individual plaintiffs who had been added to the case. Eventually, in 2013, 10 years later, the parties reached a settlement agreement, essentially agreeing to do what the judge had ordered in the first place, albeit with different procedures. So one can understand why everybody would have breathed a sigh of relief after this long journey. Stage two is the morning after. Like most honeymoons, the euphoria doesn't last, and everyone comes down to earth. Usually 12 months to 2 years into the implementation process, the defendants realize that the job is much harder than they anticipated, that the crisis, which created an expectation of flexibility, has given way to bureaucratic resistance to the reforms that had been agreed upon by attorneys or policymakers or political leaders. In the Willowbrook consent decree, for example, there were a number of things that the state agreed to do within 13 months of a new governor taking office. In hindsight, it seems clear that the lawyers negotiating the consent decree did not fully appreciate the complexity or the time involved in making fundamental changes in public policy, let alone implementing them in a very large and decentralized service environment. Willowbrook was one of 50 state institutions in the Department of Mental Hygiene, and it was a struggle to give it the attention it required with so many other demands of the department and the state. Recall again that the city of New York was facing bankruptcy at the same time as this judgment had been entered. And truth be told, the conditions in Willowbrook weren't fundamentally much worse than many other state institutions in New York or elsewhere in the country at the time. In reality, not much was actually accomplished in a short time. Usually at this stage, the defendants discover that reform needs the buy-in of a host of people who are not covered by the court orders: legislatures, independently elected officers like the Attorney General or the Comptroller, who in New York are both involved in the timely processing of state contracts, personnel agencies, labor unions, local governments, zoning boards, private providers, state licensing boards, and so on. And usually in this period, the first signs emerge that the parties may be viewing compliance issues very differently. For example, in a consent decree in a prison reform case, the state agreed to adopt new policies dealing with mental health services in their prisons. They thought that writing new policies was all they were required to do under the decree, and seemed surprised to hear that the plaintiffs would assess compliance by seeing how their revised policies actually affected the identification and treatment of mental illness among the prison population, which was a far more demanding expectation. And there can simply be a misunderstanding and miscommunication between the parties. In the Willowbrook case in New York, for example, the consent judgment established staffing ratios for the institution and had separate ratios for adults and children, with the latter being a much richer ratio. When the state calculated the cost of complying with the staffing ratio, it used a long-standing practice of calculating the children's ratio based on the population of residents under the age of 13. The plaintiffs, however, had assumed that this ratio applied to anyone under the age of 18, which was the commonly understood age of majority. They were surprised and dismayed to see the state's assumptions. The difference in expectations between the parties amounted to an expenditure of several $million more annually, money that the cash-strapped state simply did not have. So we come to stage 3. This type of divergent expectation and understandings can lead to resentment of the decree by the defendants and the relentless pressure by the plaintiffs to comply. Defendants discover that the plaintiffs don't have much sympathy or understanding about the struggles the defendants are going through to implement the agreements. The defendants may feel pressure from the legislature as well to account for all the additional money that has likely been pumped into their system of services. And they also feel the lack of support from other agencies whose help they need, but who resent their favored status in the budget and political process. And usually about this time, many of the key actors on the defendant's side leave their jobs, or there is a governmental reorganization, and new people come in who don't have the same degree of understanding of the issues or commitment to the goals of the judgment. There may be a new governor or mayor, a new commissioner, new lawyers. These people were not involved in the negotiations and may not have the same types of personal relationships with the plaintiffs. They weren't in the trenches when the litigation battles were being fought, and they often wonder about their predecessors. What were they thinking when they signed this agreement? I have to confess that when I was assigned to the Willowbrook case shortly after the consent judgment had been signed, and I read the 29 single-spaced pages of steps, standards, and procedures, although I knew nothing about running an institution, I too had the immediate and visceral reaction. What the hell were they thinking? So you come to stage 4, where this resentment ripens into opposition to the judgment and resignation to new litigation. This may happen either because of a frontal challenge to the original judgment, a motion to modify it due to a claim of impossibility or changed circumstances, or a motion for a finding of contempt or enforcement of specific provisions. Less frequently, there is a motion by the defendants for a determination of substantial compliance, which tests the differing expectations of the parties. And often this ends up with a new consent decree or a settlement agreement, and the whole process and cycle starts again. In Maine, the Pineland Court Orders of 1978 were replaced by a community consent decree in 1994. The Forest Haven case in DC had an initial ruling in 1978, and at least 5 sets of orders after bouts of litigation in succeeding years. In some cases, like the Wyatt case in Alabama, there have been 4 to 5 such cycles over the years that the case has been in existence. And the adult home case in New York that I'm working on currently, the 2013 settlement agreement has had a supplemental agreement entered into in 2018 with a new deadline in 2023. From this discussion, it can seem that there is no hope but an endless cycle of agreements, disappointments, disagreements, and more litigation. But the reality is that these cases do end eventually. And importantly, when they end, the systems they try to reform are generally left much better than they were at the start. So what are the keys to success in implementation? I like to think of the 4 C's that underpin success. First is having competent and committed leadership in the defendant agencies. Courts can order defendants to make systems change, but it is the defendants who have to figure out how to do it. This requires both commitment to the job of reform and competence in the execution of the necessary tasks, navigation of competing interests, finding allies, and sustaining the effort over a long period of time through the inevitable ups and downs. Some of the cases I mentioned earlier took as long as they did for a variety of reasons, including initial resistance to the court orders and the lack of competence and know-how to implement the reforms that were needed. In one mental health case, for example, 2 of the key leaders of the department implementing the court-ordered reforms were a real estate broker and a used car dealer whose only qualifications for their jobs was that they had run for political office and lost. But even with committed and competent leaders, the work is not easy, especially in trying to move bureaucracies to do things that have never been done before. The second is having continuity in key positions to sustain the effort over many years. George Romney, who before he became governor of Michigan, had been the president of American Motors, once commented that it took 14 years between the decision to make a small American car and when the first AMC Gremlin rolled off an assembly line. He said that that type of long-range planning and execution is difficult in a government environment where legislators and governors have to run for office every 2 to 4 years with no assurance of returning to their positions. And this is actually one of the strengths of a bureaucracy. If it has competent and committed people, that the work can go on despite turbulence at the top. Third, it is essential to have clarity about how one is going to go about implementing court orders so that all who are assigned the task understand what they are supposed to be doing and why. Equally important is a good system for tracking progress with measurable milestones along the way. Mid-course corrections are almost inevitable, but the need for such corrections will not be apparent unless there is a clear way to measure progress. Finally, it is important that the plaintiffs who bring these cases maintain consistent pressure for compliance. Absent this, it is easy for a bureaucracy to settle back into old habits and old practices that create the problems that are the subject of reform efforts. In most of these cases that continue for a long time due to turnover on the defendant's side, the most consistent actors are the institutional plaintiffs and the judge. However, plaintiffs' attorneys also need to understand the environment in which the defendants are working to implement reforms so that they can be strategic in their advocacy in finding the right points of pressure for the right outcomes. They can be important and effective allies, but reflexive and unrelenting criticism of the defendant's efforts can be both demoralizing and cease to have any effect. It is essential to acknowledge and applaud progress and small victories in the long journey to reform. In closing, I'd like to tip my hat to the advocates who launched these systems reform efforts and who have persisted through long campaigns, disappointments, and reversals to achieve their goals. To the courts, which have recognized that having rights is meaningless unless there is a means to enforce them. And finally, to the many public servants who undertook the hard work of translating written statements of rights into actual programs and services that have benefited tens of thousands of people who have been affected by court-ordered reforms. Thank you.
Thank you so much. We do have some questions, so we'll start with this one. This individual says, great talk, and then adds, many jurisdictions are only able to budget for 1 or 2 years at a time. On the other hand, resolving class actions can take years of sustained expenditure. What are some strategies for overcoming these barriers to successful resolution?
You put your finger on probably one of the thorniest problems in implementing these court orders. In the system of government that we have, where the legislatures hold the power of the purse, and courts really cannot order a legislature to appropriate money. Typically, the governor of a state or the mayor of a city are the defendant in these cases, and the court can pressure that person to use their best efforts to persuade the legislative body to appropriate the funds. But it's an ongoing challenge. And there have been cases in which either because there's been a fiscal crisis or there's just been a refusal on the part of the legislature to appropriate money, you wind up with a confrontation between the parties before the court, because the lack of funds makes it impossible to implement the court-ordered reforms. And these may lead to citations of contempt and so on. So smart plaintiffs recognize that winning a victory in court is part of the battle. But in order for the kind of reform that these cases require, it requires having a political constituency behind the reforms. In many situations, this requires helping organize advocacy groups, reform-minded professionals, family members who are affected by the lack of services or the lack of appropriate services, former residents of institutions. Having those kinds of voices making themselves heard by the legislature helps to sustain the movement for reform over a long period of time. And those efforts are also not easy to do, but they're essential for long-term success. Because one of the important things to remember is even after the court disengages from the case at some point, if nothing is done, if there is no constituency for the reforms, the system is going to slide right back to where it was before. So it's important that there be the civic society engaged in the process of supporting these sorts of reforms and supporting the governors and mayors and legislators who make them possible.
Thank you. The next question is, what are the best current sources of standards for mental health services in correctional settings like jails and prisons?
That's a good question, and I wish I had a current knowledge of it. I know the American Correctional Association publishes standards. There are other organizations, particularly when it comes to clinical care, who publish standards. But I cannot give you a citation off the top of my head. But if whoever's asked that question wants to email me, I'll look it up and get back to you.
So next question has to do with deterrence. In addition to the work that you've been doing, do you believe that there is a place for holding elected and appointed officials responsible for some of the problems that these lawsuits are hoping to fix? And do you see deterrence as important in these situations?
Well, in this political process that we have, I mean, the way in which people are held accountable, I mean, there's essentially two ways. One is if you are a defendant in a court case and you willfully fail to implement an order of the court, you can be held in contempt, and there are punishments that flow from that, including being put in jail. The other process is at the ballot box. If people don't do their jobs long enough and wind up having to spend a lot of money defending themselves and basically squandering taxpayer resources, the sanction for them is, at the ballot box, getting voted out of office. There have been cases where, the kind of willful defiance of court orders has caused the jurisdiction to expend millions and millions of dollars on legal fees, defending the indefensible. And sooner or later, people get fed up of this kind of waste of money, which doesn't actually solve a problem, but just continues to fight. And the sanction for that is not a judicial sanction; it's a political sanction.
Next question is, in terms of implementation, do you use specific implementation strategies or measures, as in pulled from implementation scientific research? Also, when monitoring, are you looking at targets missed each month or quarter and identifying why the state may have missed the mark?
Yeah, a lot of this depends on how the court orders are drafted. Most of these cases wind up with a consent judgment or a settlement agreement where both sides essentially sit around a table and come up with an agreement. And so they vary tremendously from one case to the next, because the environment and the relationships between people vary tremendously. So as an example, the case that I'm working on in New York has had a 4-year deadline for the state to accomplish certain tasks, and there were no interim milestones until year 4 to measure whether they were in compliance or not. And in my opinion, that's way too long a period of time to have a mile marker along the way to see, are you on track to get to where you need to be in year 4. There are other cases where there are much more granular compliance measures along the way. So it may be, monthly is probably a little bit too short, but quarterly or, every 6 months, that there are measures to look at, how is the work progressing. And I think that's probably necessary and desirable, because if too much time goes by without being on the right track, I mean, you're essentially digging a hole that it's eventually impossible to get out of, because you've got to redouble the efforts, and you got to redouble the efforts. And if you're 6 feet into a hole when you start, the job becomes that much more difficult. So if you're asking about a best practice, I would say the best practice, even if there is not a court order that requires these kinds of milestones, a smart defendant would have a work plan that has measurable milestones, probably at least every quarter, to see that essential tasks are being performed on time, and have an opportunity to measure the effectiveness of those tasks in achieving the outcome.
Can you comment about iatrogenic effects of such settlements? So for example, individuals with intellectual disability dying soon after being placed in the community, huge wait lists for Medicaid waivers, money diverted from other state agencies, et cetera. And then what about the creation of a self-perpetuating cycle to support the industry of attorneys, experts, and monitors by such lawsuits?
There's a lot of questions embedded in that one question. there's two ways of looking at the what you refer to as the iatrogenic effects of these settlements. What has typically happened is that people who are protected by litigation because they're part of a defined class tend to have priority in getting access to services simply because there is a court order that requires them to be served, and that distinguishes them from everybody else. So it's unquestionable that in the real world, there are people who are similarly situated who, for whatever reason, are not part of the class and don't have the same access to the services that they need simply because they're not part of the class. But I think what experience shows is that over time, the pressure of serving the class tends to benefit everybody else because government has got to create systems to develop the services, not only for the class, but the politics then require that you make services available to everybody else as well. To give you an example, in the Willowbrook case in New York, where the state was required to close an institution with 5,000 beds and develop group homes and community residences for this class of people. So of course they had priority. The state was spending a lot of money developing group homes, and as one could expect, there were families who had people with intellectual disabilities living with them who were saying, well, what about us? We need access to these types of community services, and we don't want to have to put our children into the institutions that have been found to be so substandard. And what happened as a matter of practicality is that as the state was developing these community residences, it basically adopted a 50-50 policy that, if we open a group home that's going to serve the Willowbrook class, half the beds will go to people who are not Willowbrook class. So the spillover effect of the Willowbrook consent judgment was essentially creating a whole system of services that never existed before for people who weren't part of the class, but gave them access to community residential services. And I think similar things have happened in other states. That said, there is a real problem right now across the country in staffing services, particularly in the mental health and developmental disabilities area, where people are desperately in need of services outside of an institution. And we've also closed most of the institutional beds, so that's no longer a realistic option. But those community services are facing significant problems, partly because of the workforce issues that's affecting the economy as a whole. They can't find workers, and there are issues with the rates that the governments are willing to pay for these services. So if people have an option to do something else, they probably will not want to work in a high demand, like a direct care job in a community residence, where you're getting wages that are probably about what you could make working at McDonald's or Walmart or Target or some other place like that. And the work is much harder. So I think these are essentially political problems. I don't think they're manufactured by the court. I think these are larger economic issues that society needs to come to terms with. There was a second part to your question, which I've forgotten now.
So iatrogenic effects of the settlements, and then what about the creation of a such self-perpetuating cycle to support the industry of attorneys, experts, and monitors by such lawsuits?
I know a lot of defendants think that that's the only reason that lawyers file these lawsuits and keep them alive is so that they can keep billing, for their legal fees. And there may be abusive situations where that might be true. I haven't seen much of it in my career, and smart judges and actually smart defendants now are negotiating in their settlements to put caps on the amount of money they're going to spend on these kinds of fees. So, I think there may have been a period of time when there was excessive, use of time to litigate stuff that probably didn't need to be litigated just to generate fees. I think it's a violation of a lawyer's ethics to be doing that, but but I'd be a fool to say it never happened.
Can you talk about a core component you often find missing from the consent decree or agreements in which you monitor?
Sorry, restate the question.
Sure. Can you talk about a core component that you find missing from the consent decrees or agreements in which you monitor?
I think one of the sort of generic issues that these consent decrees don't address very well is a clearly measurable way of determining when is this done with. I mean, a lot of these cases have vague standards of compliance, everybody should be in the least restrictive environment. Well, what does that actually mean, in real terms? Sure, there are a lot of people who could live in supported housing, for example. Some people need much more support than supported housing can provide. So what is the least restrictive environment for that person? Is there ever a place for a 24-hour congregate care facility in a service system? When you don't have a fairly precise compliance measure that anybody can look at and say yes or no, that leads to a lot of litigation about, are you in compliance or are you not in compliance? So I think if there's a generic flaw in these cases, that's probably it, that they have not clearly defined what is the end of this lawsuit.
So next question is, in the current political climate, states are, deciding on lots of public policies. Do you think that this has increased the vulnerability for, human rights in terms of the disabled, mentally ill, and others that have been discussed in your talk today?
Very much so. I mean, I think you just need to travel to a number of different states to see the tremendous gulf there is between the availability and quality of services in some states compared to others. The relative wealth of the states may have something to do with it, but I think a lot of it also has to do with the political power or lack of it of the constituency groups that these human service systems serve. Because states that actually have a fairly good level of income just choose to spend it on different things. So yes, I think that's, if there's sort of a structural issue with, having 50 states which are sovereign in many ways, they are free to make those sorts of decisions. And, over the course of my career, I've come across people who have moved from one state to another simply because they have a disabled child, and where they were living, the educational facilities were terrible. The clinical services that their child needed, therapies that they needed were just not available. And there was very little government support to make them affordable if they were available. So people have, gotten up and moved to another state that has a richer array of services, better educational systems, better special education, and so on. So I think you put your finger on a real problem.
All right, one more question, and while we do that, the survey for the CEs has been posted in the chat, so make sure y'all click on that and fill that out so you can get your CE certificate. So the last question for today is, a lot of people feel that deinstitutionalization has had a negative effect on people with disabilities. Do you think that deinstitutionalization has been an improvement over custodial care, and if so, how?
Oh, I don't think there's any question that it's been a beneficial thing overall. I mean, just think about it. When, in New York State, for example, we had a mental health system that had over 90,000 people living in psychiatric institutions. And I visited most of these places, and many of them had, even the best of them, basically had people vegetating and wasting their lives, doing nothing productive, having no real opportunities to do anything. Most of those people left those institutions and are living in the community. Many of them are leading productive lives. They're working. They have relationships with other people. They have social lives. And I think the developmental disabilities field has probably done better with that because, they've understood their obligation to people to be a 24-hour, 365 days a year obligation. And so there's much more support, much more supervision, a better safety net for that group of people. And these are people who were living in institutions like Willowbrook in the 1970s and earlier. It's unquestionable that there have been casualties of this process. The homeless crisis that we had and still have to some extent, is part of it, but it's not purely a product of the mental health system policies. It's largely a product of what happened with support for housing and the lack of development of low-income housing. And in fact, the total abandonment of federal support for housing that has led to so many people not being able to be sheltered appropriately. And we're seeing it even today. Affordable housing is an issue in virtually every community in this country. All that said, there are people who unquestionably, suffered as a result of deinstitutionalization because there was a lack of services available to them when they needed it. They weren't there in sufficient quantity or quality and accessibility for them. But I think if you're looking at a public policy writ large, the casualties amount to a relatively small proportion compared to the people who benefited from having more control over their lives and the ability to make their own choices about how they wanted to live.
All right, thank you so much. We really, really appreciate your time today, and this was fantastic.
Good. Thank you.
Thank you. For those of you who are still here, we'll be on for just a couple more minutes. Make sure you click on that survey link and save a copy of it for yourselves. Otherwise, we will see everybody next week. And thanks again, Mr. Sundram.
Okay.